Good evening, ladies and gentlemen. I'm put in mind of my attempt at Lincoln's Inn a few years ago to explain to an early dinner audience consisting of young trainee barristers and the benches of the inn. I said, in Africa, we reciprocate. So I said, good evening again. And there was stony silence. Good evening, ladies and gentlemen. How are you? I see one fellow African, a much admired fellow African. He knows it's wonderful to be here. I was warned that the weather in Dublin would be dank and dark and the people would be warm and wonderful. And both have been proved true over the last 2 days. I must say that, Peter, you spoke with passion and with clarity and with a barrister's lucidity and fervor. And I don't know much about Irish politics. I've never met Minister Ross. But while you were speaking, I was put in mind of a joke that was told for my benefit just last year when I was invited as one of the guests of honor to Alcoholics Anonymous. A very close friend of mine belongs to that organization. I hope you have it in Dublin as well. It's a very, very fine organization. And because I was there, the chairman told the following joke. And it indicates the kind of esteem which I think you're reflecting Minister Ross holds the judiciary in. And it concerned a criminal accused in a drunk driving trial. And the policeman was called and gave the usual evidence. The criminal accused was slurring and couldn't walk along a straight line and couldn't give coherent answers and couldn't look him in the eye. And the judge was getting increasingly irate and leaned over the podium and said, "Mr. Accused, just how drunk were you?" And he said, "I was as drunk as a judge." So the judge drew himself up and said, "I beg your pardon. I believe that the apposite term is as drunk as a lord." And he said, "Yes, my lord." So I don't know whether Minister Ross has the same view of the judiciary, but thank you for your passionate words, Peter. They seem very, very timely and very, very important. And ladies and gentlemen, it is a great honor for me to give this lecture this evening. I've met Dave Ellis's widow. I didn't meet the rest of his family, but it's a great honor for me to be here and to try to carry on the tradition of the previous speakers, one of whom is present here, Martin O'Brien, who's been a great friend to South Africa and who supported many, many legal and public interest initiatives in our country. So I have a sense of myself as at the end of a tradition of speakers who have shown a commitment to access to justice. And I want to thank Nolene Blackwell, who initiated the invitation to me, and Eilish, and Yvonne Woods, and the whole staff of FLAC, who've done an enormous task in bringing me here and providing me with 2 fascinating and engaging days. It's been a great privilege to be here. And I want to say one more thing. I had the great opportunity to spend some time with Mary Robinson today, and she knew Dave Ellis. And she spent quite some time speaking about him, very vivid and intense memories of him. And the one thing she said that really stayed with me is that she said he would have been absolutely astonished to know that an annual memorial lecture had been named after him. She said he was the humblest person, the most modest person. And that really filled me with warmth to think that such a person of such profound commitment to access to justice would never have expected this. And that invests the evening, I think, with greater joy. We can see access to justice as being able to seek and obtain an effective remedy for legal or human rights wrongs through formal or informal institutions of justice, and remedies that are in compliance with human rights standards. Someone has explained that President Mandela, our fabulous former president in South Africa, may have had human rights, but he did not have effective human rights. This was because South African law did not recognize them. Hence, the legislation and adjudication of human rights law, or its lack, retains a prominent place in human rights studies, globally, regionally, and locally. I want to tell you a story tonight about my country's transition from an extremely oppressive form of law to one that is committed to one that I think is quintessentially one based on access to justice. But before saying that, I just want to pause for a moment about the role that organizations like FLAC play. And I want to say that we have discovered in South Africa that with our constitution, I had a meeting yesterday at FLAC with a range of organizations. We sat around a table and we discussed ways of creating access to justice for sex workers, for migrants, for those with HIV, for LGBTI people, for people in various stages of legal dispossession or distress. And it struck me how similar the work is that we're doing. What we have in South Africa is a far greater legal vehicle for taking cases to court. But the work of organizations like FLAC has remained absolutely indispensable. In fact, we've discovered 22 years after our transition that we've begun relying ever more on legal NGOs, on access to justice NGOs, including those that people like Arnold Tsunga, who's here tonight, represent. So far from our transition seeing a diminution in the importance of organizations like FLAC, it's only accentuated our understanding of them. So the story I want to tell you, ladies and gentlemen, I think is an interesting one. It's one that I won't tell at too great length because I want to have your questions afterwards. But it's a story that I think asks three questions. The first is, what counts as law? And of course, under apartheid, we had the classic evil legal system. The textbook classic after Nazi Germany was apartheid law, rightly denounced as an international crime against humanity because of its use of the law. The second question is, what is the purpose of law? And that, I think, has been answered over the centuries to retain order. But of course, that's not a sufficient answer, because you can have the order of the grave, which is entirely lifeless. And then you get on to the third question, which is, to what uses can you put a legal system? And all three of those questions have been acute in the debates of both pre-apartheid and post-apartheid lawyers. And the reason is that apartheid was not the most bloody human rights atrocity on the African continent. There were far more blood-drenched atrocities in South Sudan and the Democratic Republic of Congo and Biafra. And as we were becoming a democracy in April 1994, in Rwanda, in April 1994, as we had our first democratic non-racial elections, 10,000 people a day were being slaughtered for 90 days, 900,000 people in the Rwandan genocide. Apartheid wasn't a bloodletting on anything like that scale. The total number of traumatic deaths was minuscule compared to the 2 million in South Sudan and 900,000 in Rwanda. But what was pernicious about apartheid was precisely its use of the law. Its use of the law to subordinate people, to deprive them of their civil liberties, to try to deprive them of their dignity and self-respect, to deprive them of access to jobs, to where they could live, to regulate even their sexual conduct. It was a minutely systematized legal system that had a particular legal brutality that warranted its being declared an atrocity against human rights. And all of this, ladies and gentlemen, to my deep shame, as a white person myself, one who benefited from the system based purely on skin color. As a white South African who came from a poor background, I nevertheless had opportunities because of my white skin to get into an outstanding secondary school, whites only, to get into a beautiful and excellent university, Stellenbosch University, whites only, and from there to get scholarships to come to the British Isles and to make my career, which gave me a profound sense of the offensiveness of racial privilege, but also a profound sense of the importance of government-created educational opportunities. The object of apartheid was to subordinate the great majority of the population, to prize whiteness, to separate, to segregate, to deprive and repress. But the fascinating thing in the first question I put to you about what counts as law is that if law is solely repressive, if it is solely subordinative, if it is only power and domination, it cannot have the character of law, because law requires some measure of authority, and to have authority, it requires some measure of morality. And that meant that apartheid law was in fact quite a complex system. You had lawyers like Nelson Mandela. His partner, the justly famous law firm Mandela and Tambo, Oliver Tambo. They were both lawyers. Joe Slovo, the head of the South African Communist Party, was himself a very active lawyer. His successor as head of the Communist Party was a hero today in South African law, a very brave Afrikaner called Bram Fischer. So you had lawyers at the very epicenter of the fight against apartheid, and that has deeply scored our transition and what law is in South Africa today. Mandela himself experienced this because he was arrested under a new law adopted when he launched the Defiance campaign, meant to be a Gandhi-esque resistance to apartheid, which for various reasons failed. Mainly amongst those reasons was that the apartheid police were much more brutal and intransigent than the British police had been in India in the 1940s when Gandhi launched his campaign. He was tried for an offence which had been newly created with a special 10-year sentence, found guilty, and expected to be sent to jail, and the judge, an Afrikaner judge, gave him a suspended sentence. He was unrepentant. He went on counselling defiance against the law, disobedience of it, and was brought to court by the Incorporated Law Society, which had a strong case. It said, how can he possibly have taken an oath to uphold the laws and the Constitution of the Union of South Africa and yet be counselling disobedience of those same laws? And the Law Society said, you've got to strike him off. 2 white judges in 1954 said, no, we will not strike Nelson Mandela from the roll of attorneys because he has acted in conscience. An astonishing thing in a repressive legal system to find judges who were willing to take a stand like that. Mandela never forgot it. He was put on trial for treason for 3 years in 1996, culminating in an acquittal of all 156 ANC-aligned accused by a specially constituted panel of 3 judges. He was put on trial again, the trial that eventually resulted in his imprisonment for life, but the indictment was quashed as inadequate by the trial judge at the start of it. Many people expected him to get the death sentence. The trial judge didn't impose the death sentence, much to our nation's lasting legacy gratitude to him. Mandela never forgot this. He had a belief in the law. He had a belief that the law, while used under apartheid for expressly and heinously oppressive objects, should be put to some other use. And that nurturance was sustained during apartheid by the fact that legal organizations like those in which many of you are participating in Dublin in this era took a lead in fighting apartheid. Organizations like the Legal Resources Center, the Center for Applied Legal Studies, where I was attached to for 10 years during my practice in the 1980s as a human rights lawyer, Lawyers for Human Rights, organizations that took a lead in fighting the pass laws. The pass laws were one of the greatest indignities that black Africans faced. 80% of our population, black Africans, they were required to bear a pass. And if you didn't have your pass with you, you were flung into a police van and put through court and sent to jail. And those pass laws were rendered inoperative by an appeal court decision based on an extremely obscure point that a wonderful lawyer who became the first Chief Justice in the Constitutional Court, the court in which I'm now privileged to sit, Arthur Chaskelson, argued, and the appeal court struck down the pass laws in the middle of the 1980s. So there was a sense at the end of apartheid of 3 important things. We had a cadre of lawyers who were dedicated to using the law for purposes of social justice and for public interest causes. These included, as I've said, Mandela himself, and they included prominent human rights organizations that I've mentioned. A second important benefit that we gained from apartheid was a fairly widely disseminated sense that despite its use under apartheid, the law and the legal system could on occasion, even if rarely under apartheid, be used to promote social justice. And thirdly, and I've often thought most importantly, and with Arnold Tsunga from Zimbabwe being here, I think that the difference between our countries, Arnold, is that we had a population that saw that you could use the law, you could use popular dissent against an evil government. So we had a population at the end of apartheid that had a profound skepticism about governmental power. And in order to have civic liberties, in order to have organizations like FLAC, like the organizations I've mentioned, you've got to have popular skepticism about power and not popular subordination to it, not popular reverence for misbegotten leaders, none of whom will be mentioned, Arnold, tonight. So, ladies and gentlemen, we had a transition, an extraordinary transition led by Nelson Mandela, a transition in which, for various geopolitical factors, including the demise of communism in the Soviet Union in 1989, which occurred shortly before the declared government committed itself to the transition. For various geopolitical factors, we had a transition at the heart of which was an agreement that we had to have a constitution with a Bill of Rights, and which would include a constitutional court, especially to guard the transition and to guard the newly acquired rights. There were specially entrenched values of dignity, equality, democracy, the rule of law, and the supremacy of the Constitution itself are specially entrenched in our Constitution. Most of the Constitution can be altered only with a 2/3 majority. Those specially entrenched values need a 3/4 majority for them to be altered. A commitment to diversity, which found itself in the very preamble of the Constitution. Diversity recognized as critical not just for being nice, but for being essential, and for the cost of non-diversity being evident in 50 years of post-colonial African history through repression of people leading to genocides like in Biafra and in Rwanda. So a profound practical sense on our continent of the necessity to be respectful of people who are different from you. And then, of course, pertinent to your own debates, in Ireland, we've got the express inclusion of a right, so different from the 8th Amendment to your Constitution, which includes the right to bodily and psychological integrity, which expressly includes the right to make decisions concerning reproduction and the right to security in and control over your body. That right is so explicit that when the government in 1996 promulgated one of the world's, I think, most progressive and most women-sensitive abortion laws, there was a challenge that founded in the High Court. It wasn't even brought to the Constitutional Court because so clearly was the constitutional entitlement to a woman's choice and to safeguard women from the heinous effects of illegal abortions was made so clear. And of course, given our history of 350 years of systematic exclusion of black people from social opportunities, from economic opportunities, we have an equality clause that says that equality includes the full and equal benefits of the law, which includes appropriate reparative measures to undo the injustices of the past. We have an express commitment right in our Constitution, one that I support and am profoundly proud of, to undo the past with appropriate contemporaneous measures based on race. It's a remarkable document, one that I think, given the theme of tonight's lecture, access to justice, is based on the conception that law has a particular task, which is to forward the dignity of people, to forward equality, and to undo the injustices of the past. It's rightly been lauded by Justice Ruth Bader Ginsburg of the United States Supreme Court. And long may she live, ladies and gentlemen. For trumped up reasons, Peter, as the world's most progressive constitution. We replaced a system of parliamentary sovereignty with one of constitutional supremacy. And the last feature I'll mention is that a debate that's also pertinent to you in Ireland, is that there's an express inclusion of social and economic rights in the Constitution in a way that I'll come back to in a very exciting and illuminating way. The commitment to diversity lies at the center of our Constitution. And of course, I benefited from it because when I was a human rights lawyer in the 1980s, I also came out as a proudly gay man. I determined that I would never again in my life apologize for being what I am. I'm white, I'm male, and I'm a homosexual. And the profound shame that attended the statement of that last item of my identity was one that motivated me to come out and to fight for gay and lesbian equality in 1980s apartheid South Africa. We achieved a world first, which was the inclusion of sexual orientation as a protected condition right inside our equality clause in 1994. And I had the tremendous honor of President Nelson Mandela appointing me at the end of the year in which we became a democracy as an openly and proudly gay man to the High Court bench. We have a long way to go in our country to secure the reality of LGBTI equality. I've read with interest what FLAC did for Dr. Lydia Foy. We also have difficulties with transgender rights, making them a reality. In many ways, LGBTI rights are emblematic of the larger difficulty of constitutional transition, the practical reality of bringing rights to people, from embodying them in a document to making them right. And that again reinforces the importance of legal access organizations like FLAC. I mentioned social and economic rights. One of them is Section 27 of the Constitution, Section 27(1). It says that everyone has the right of access to health care. And that provision is followed by Section 27(2), which says that government is under a duty to take reasonable legislative and other measures to secure the right of access to health care. Little did we know when that was legislated as part of our Constitution 10 years before, that it would come to the fore in the most ghastly way imaginable, which was through the HIV epidemic. As we were becoming a democracy, as the negotiations started, it was manifest that the shape of the epidemic in Africa would be totally and perhaps catastrophically different from that it took in your country, still takes in your country, mostly with men having sex with men and injecting drug users. The shape of the epidemic in Australasia, in Western Europe and North America. In Africa, by the late 1980s, it was quite apparent that it would be on a massive scale an epidemic of heterosexual transmission, principally amongst very poor people, and whose burden would fall most particularly on black women. And it was an epidemic, ladies and gentlemen, not just of a virus, but an epidemic of shame. I experienced that shame myself when I was diagnosed with HIV this very month, 30 years ago, in December 1986, I was diagnosed with HIV. And the catastrophic impact of that was twofold for me. The one was that I knew as a 33-year-old man that I would never turn 40, I would never see a democratic South Africa, and I would never see any of my life ideals fulfilled. It was a death sentence. In 1986, it was absolutely clear that there was nothing one could do but await an eventual decline in the immune system and a conversion to AIDS and a catastrophic destruction of the body's capacity to fight off illness. But worse than that, literally worse than that, was the sense of shame I felt, ladies and gentlemen, the enormous sense of shame at having come out as a gay man, having started to fight for equality for gay people, gay and lesbian people in my country, and then becoming infected with this shameful virus. I fought that battle for many years until I came out myself as also living with HIV. What produced my public statement about my HIV were two things. The one is that I fell severely ill 3 years after President Mandela appointed me as a judge. In 1997, I was very, very seriously sick with all the major symptoms of AIDS, and I'd lost a significant portion of my body weight. I was severely ill, and I faced death on a median survival time of 30 to 36 months for a healthy person, a middle-class person with defined life goals and ambitions and good care. I was going to live for approximately 30 to 36 months in November 1997. But of course, I had access to the new antiretroviral treatments that had just become available. I could afford them because I was earning the salary of a judge. Across in Durban, there was a young woman called Gugu Dlamini. She was a sex worker. It's not often said about her, but her daughter, Mandisa Dlamini, with whom I work closely, has recorded this, and it's important to know that she was a sex worker. And part of the reason for what happened to her was fury from those who'd had sex with her about what she did very bravely. A year after I was so ill, on the 1st of December, World AIDS Day, 1998, she went onto the Zulu language radio station in Durban and spoke about herself as living with HIV. And 3 weeks later, Gugu Dlamini was killed in her own community, stabbed and stoned to death. And that was what precipitated my imperative sense that I had to speak out. I was living behind a palisade in suburban Johannesburg with the salary of a judge on antiretroviral treatment, which people like Gugu had no prospect of getting in 1998. And I spoke out because within 10 days after taking antiretroviral treatment, I knew that my life had been given back to me. The virus had stopped working, and it's been 19 years now that I've been on ARV treatment, and the virus has been inactive for all that time. And the sense of joy and the sense of revival of my life quite literally being given back to me was enormous. And my gratitude continues to this day. And I spoke out in honor of Gugu Dlamini. And I joined the campaign started by Zaki Ahmed, who was a brilliant defender of gay and lesbian equality and an ingenious rights campaigner for them in the courts. Zaki started the Treatment Action Campaign in 1998 in order to tackle the question of drug prices, and he won that battle. He won that battle. Within 4 years, the Clinton Foundation and the Gates Foundation had concluded a deal with the major drug companies to allow drugs to be manufactured cheaply in Africa and India. And that led to the accessibility of drugs also in Africa. But what we didn't contend with was a nightmare when President Mbeki was succeeded by when President Mandela was succeeded by President Thabo Mbeki, his deputy president, in April 1999. President Thabo Mbeki, a proud man, an intellectual man, a man determined to restore the pride of Africa, the pride in blackness. And that was his downfall, of course. It was his own shame about this epidemic that was by now rampant in South Africa by 1999. We were having, we think, between 350,000 and 500,000 deaths per year from AIDS. And President Mbeki refused to accept that this was the consequence of a sexually transmitted virus. The shame that he radiated was enormous. And the skepticism about the etiology of AIDS came from that shame, and in its turn, it enormously magnified the stigma surrounding HIV. It was a catastrophe. It was an absolute catastrophe. It was mistaken, of course, because the particular shape of the epidemic in Central and Southern Africa has nothing to do with blackness. If it had to do with blackness, you'd have an equivalent epidemic in West Africa. The highest national prevalence in West Africa is 3.8%. Nothing like the prevalence that we have in South Africa, Swaziland, Botswana, Zimbabwe. It's not to do with the way in which black people have sex, which is what President Mbeki said the white scientists and the epidemiologists and virologists were saying about black Africa. It had nothing to do with that. It was a simple virus, and he re-stigmatized it. But the Treatment Action Campaign turned its attention to President Mbeki, took to the streets, made demands, took to the media, formed alliances, very important. We've been talking the last 2 days about the importance of alliances with other organizations, with churches, with trade unions. And they took President Mbeki and his health minister on, Health Minister Mantu Chabalala Msimang. And they eventually, when they proved intransigent, as the death toll was rising, as the suffering was rising, as I in my protected condition knew how enormously effective these antiretroviral drugs were, as I knew that my life had been given back to me because of them, I could not remain silent, and I joined the campaign, the critique of President Mbeki that Peter has referred to. Ultimately, the Treatment Action Campaign, having exercised almost every right in the Bill of Rights of expression and association and movement and freedom, eventually exercised the right in Section 34 of our Bill of Rights, which is the right of access to court. And they took President Mbeki to court on the basis of Section 27. Section 27 won the right of access to health care. Section 27.2, the obligation by President Mbeki's government to take reasonable legislative and other measures to ensure their right of access to health care. And they challenged his policy on antiretroviral treatment as unreasonable. And that was a battle Chief Justice Arthur Chaskelson and Deputy Chief Justice Pius Langa, court of which I was not privileged to be a member. I joined it a 4 years later, ruled that President Mbeki had to start making antiretroviral treatment available. The particular case, the particular legal question was whether a woman starting parturition, just about to go into childbirth, was entitled to take antiretroviral treatment to protect her baby. It was a perfect case for a public interest lawyer to choose. The drug that they sought to make available through the public health system to the women was being provided free by the German company Boehringer Ingelheim. It was only ideology on the part of President Mbeki, a shameful lapse in logical thinking, impelled by the stigma behind AIDS, that led him to refuse to make it available, and the court said no. The court ruled that he had to start making antiretroviral treatments available. It was a pivotal moment in our constitutional transition, one that was attended by great uncertainty as to whether President Mbeki would follow the court case. His health minister said no. Sometimes the courts must listen to us in the executive. And then the next night he sent his own minister, Minister Penwell Maduna, onto national television to say, no, we will follow the case. In other words, President Mbeki, to his great credit, subordinated himself. He hung his head before the rule of law and the Constitution. It was a pivotal moment, and it was one that grounded our Constitution and that has laid the basis for what we are doing now in the court, in a period of even greater executive turmoil, in which a president who many don't regard as being in favorable terms with President Mbeki, President Zuma, the present president, is subjected to great criticism. I do not associate myself with the criticism for obvious reasons. He's a litigant in our court. But in that contested arena of our national executive and presidency, the role that the courts play was secured for them by President Mbeki's enormously providential act in bowing his head before them and agreeing to implement the Navarrepine decision. Since then, ladies and gentlemen, we have acquired the world's largest publicly provided antiretroviral treatment program. 3.5 million people, like myself, have their lives to attribute entirely to the availability of antiretroviral treatment. There's still many problems, too many young people, like in your country. The prevalence and incidence amongst young gay men are both rising in Dublin, here where we are tonight. And the same is happening in my country. Young people who know that HIV can be medically treated. We have to find ways to get the message across to them, ways that are non-prescriptive, non-condescending, non-patronizing, ways that encourage them to make health-seeking behavioral choices. It's a complex issue. It's a very complex issue. But it's one where we have the strength on our side of the rationality of medical treatment, the virological coordinates of HIV, its affection, its virology, and its epidemiology are no longer disputed. But we have to get across to young people to protect themselves, because more people are being infected than are coming onto antiretroviral treatment, which is a prescription for calamity. We've had many cases in our court, ladies and gentlemen, which have matched the access to AIDS case. Many of the cases in which we deal in the court in which I now sit, I've been there, as Peter said, for the last 8 years, deal with social and economic rights, the right to housing, the right to water, the right to social security, but none of them matches the drama or the brilliant impact of the HIV case. I want to draw to a close, Peter and Eilish, because I want to spend the last 4 or 5 minutes in just reflecting on our Constitution after 2 decades and reflecting on its impact in the light of the theme of tonight's lecture. What have we achieved for ordinary people in a country that was brutalized by a legal system designed to exclude them, and which is now graced by a constitution that is expressly based on inclusion and on access? There's much to be concerned about. We have high rates, especially of violent crime, near-endemic gender-based violence, rape of children and of women, disintegration of attacks on independent institutions. We have abuse and maladministration of state-owned enterprises, and we have widespread pillaging and corruption by government officials and politicians of the exchequer. And yet, amidst these conditions, what do we have? We have the law. We have the law, and we have the world's finest constitution. And the joyful news I can bring to you, ladies and gentlemen, is that it's not dead. And the theme that keeps it alive is not the paper on which it's written or the beautiful words in which it is expressed. And both of those are important. Words are important. It's the sense of the people behind them who remain skeptical of governmental power. People who come to our court, every single political party, the opposition parties, the governing parties, they all make constitutional claims. People, service delivery protests in our country, they make constitutional claims. They have a sense that if there were less looting and pillaging by public officials and by politicians, they would have the water to which they're entitled, the sanitation and the housing. They are making significant constitutional claims. Most importantly, we have what I see as the widespread internalization of a sense of constitutional agency. I see it amongst young LGBTI people. It's real. It's a sense that we are still at risk. Lesbians in townships are at particular risk, but nevertheless, what is the difference that a constitutional right makes to a young 14-year-old with a growing sense of his or her sexual diversion from the majority? It's a sense of dignity and a sense of constitutional agency, a sense of constitutional citizenship that Alish quoted from earlier. And what is the role of lawyers and judges? I want to quote from your president, President Michael D. Higgins. He said, "The challenge for the human rights lawyer is the challenge to seek out violations of human dignity beyond those that are popular or obvious, to identify violations of rights and dignity not previously understood, and to conceive of new realities where through imaginative and creative application of the law, human dignity can be vindicated, can find greater and freer expression." That's a beautiful expression of why we are here this evening, ladies and gentlemen. The importance of social agency and of transformation requires us to see the limitations in our present society and where the frontiers of human rights enforcement lie. It may lie in food stamps. It may lie in access to water, but it might lie in protecting travelers or the Roma population. And without the widespread and continued support of society actors that legitimize commitments embodied in constitutions, courts are just buildings, judges are just bureaucrats, and constitutions are only a piece of paper. That's my tribute to what work you are doing, to the work that the volunteers do, and it's my tribute to FLAC, and I thank you for listening tonight.